Hi, folks. Today we're going to talk about your estate planning documents. My name is Jim Noble. I'm a certified financial planner, registered investment advisor, and wealth manager here in New Jersey. And here in New Jersey, we have a thing called probate, like we do in 50 states across the country. And let's talk a little bit about how to avoid probate and what are the most important things that you can do to protect your family in retirement and beyond. Here are some of the common estate planning questions. What's better, a will or trust? How does probate work? Can it be avoided? And what taxes are due? So let's start with the easy part, the taxes, right? So for most of my clients, there are no inheritance taxes for most of my clients. Now, there's two tax systems for inheritance that we have to navigate. One is the federal estate tax system, in which families with individual assets of $11,580,000 are not subject to tax. And if you multiply that by two, that's what a couple has. In a few years, they'll be cutting that in half based on the tax law changes that are pending. But still, that leaves over $5-6 million per person. For most of my clients, that's not an issue. However, we have New Jersey inheritance and gift tax to consider. While it was mostly repealed, it was not entirely repealed. It still applies to what are called Class C beneficiaries. And, what other taxes do we consider? So for most people, the estate tax is not a big thing, right? But there are taxes to consider. Income tax in your last year, in income tax on IRA assets for your beneficiaries, and deferred income tax on non-qualified annuities. So if you have an annuity that hasn't been paying you distributions of your earnings, those earnings are deferred and accumulating and will be taxed eventually. Let's go through the estate planning checklist. These are the things you must have: medical directive, living will, healthcare power of attorney, durable power of attorney, revocable living trust and or a will, and they work together, instructions for any digital assets that you have, and disposition of your last remains. You have to tell people what you want. Now, let's look at a scenario, very common: older couple in a car accident, and their adult children come to the hospital. But guess what? No one's going to tell them anything because they don't have a healthcare power of attorney. Properly drafted advance directive enables the agent to obtain information and make healthcare decisions for a person who's incapacitated. It is not the same as a living will, which gives specific end-of-life instructions for the agent. It is the piece of paper, the advance directive is the piece of paper that gives you permission to act on their behalf. The living will is where they told you what they wanted. Key fact: what's an agent? Who's an agent? An agent is also known as a fiduciary who has the power to take actions that must only be in the best interests of the owner, grantor, or individual. This is a legal responsibility that for which the agent can be held legally liable for actions taken or not taken on behalf of that individual. So when you have assigned a healthcare proxy or anyone to act on your behalf, they are legally obligated to only act in your best interest. Scenario 2, joint tenancy. Lots of times we hear about putting one of the adult children on the house to simplify the estate later. So in this case, a parent puts a child on the house and on their bank accounts just so that they make it easy. Well, you don't need to do that if you have the right documents. Now, first of all, if you've already established a trust, then there's no need to put someone else on that document. They're already there. They're the trustee. Or in this case, if you had a durable power of attorney, and assets were not held in trust, then that person with the power of attorney has the right and the obligation to act on that person's behalf. So the durable power of attorney would enable the daughter to pay the bills while keeping title of the assets separate. And that is important. Scenario 3, incapacity and conservatorship. Well, again, a revocable living trust is going to take care of the finances. Advanced healthcare directive is what enables you to make decisions on their behalf. By creating and funding a trust, financial assets can be directed by a trustee And the healthcare directive enables health-related decisions to be made by that agent who has accepted the power. Scenario 4, if your spouse is in a coma, becomes incapacitated, and your spouse has an IRA, what access will you have to that money? If you don't have the proper documents. Well, what do you need? You need a durable power of attorney. So an IRA is an asset held by an individual, not by a couple. And there is no separate entity unless that individual has assigned someone to that responsibility by creating a durable power of attorney that enables that person to make decisions on their behalf and access funds. IRA assets that are not in a trust can be accessed by a spouse for the benefit of the owner with a properly drafted power of attorney that has been accepted by the custodian and added to the specific accounts as requested by the client or the agent. So typically when you set up this power of attorney, you want to let your financial institution know that it's in place rather than trying to put it in place when you need to, because oftentimes that can be a problem. Now, what are the unforeseen circumstances that can occur that make this sort of ad hoc estate planning dangerous? Well, anything that you have gifted or anything that you've titled to someone else, you've essentially gifted it to them. If they go through bankruptcy, well, then those assets are attachable. They're also attachable through divorce or a lawsuit. And again, we have other issues of loss of control if we've titled our property into our children's names, guardianship issues, probate, unnecessary costs and delays, and spousal impoverishment can happen as well. We've seen this happen where one spouse didn't properly update their beneficiary forms and passed away and left an IRA, large IRA, to an ex-spouse. Bad planning. Now, your estate has three names: the taxable, the probate, and the non-probate estate. Taxable estate is taxable both at the state and the federal levels. The probate estate, each state in which you own property when you pass away, requires that those assets be probated. So typically, financial accounts don't qualify as probatable by domicile, but real estate does. So if you own a property in Florida, Arizona, your beneficiaries are going to have to probate that property in that county of jurisdiction. So by establishing a revocable living trust, you avoid all of that. Now, probate court. What is probate court? It's the first step in the legal process of administering a deceased person's property under a will that you create or the state creates. So if you die without a will, there is a will. It's called the law of intestacy of the state that you died in. And the state has beneficiary designations set up based on family relationships. So if you have someone you want to be in charge of that and you haven't set it up, it's not going to happen. Now, why are we talking about probate court? Well, for the last 2.5 years, we've been going through unprecedented times in which we no longer have traditional access to the court system. So during the pandemic, the courts were closed to visitors, and the process of filing probate became dramatically more complex and time consuming. So if at all possible, you want to stay out of probate court. Not that hard to do. The COVID-19 pandemic has created permanent delays in the court system that may last for years. They've also changed the way the courts do business. Now, assets that avoid probate are anything with a beneficiary designation: IRA, 401k, pension annuity with a survivor benefit, life insurance policies, deferred annuities. Anything owned by a trust has its own self-settling beneficiaries. Update your beneficiary forms. All accounts with beneficiary designations must be updated to be sure that your wishes are granted. Remember the ex-spouse that we just talked about. Now, that would include life insurance policies, annuities, IRA accounts, and there is a distinction between spousal and non-spousal beneficiaries with respect to IRAs that's important. Now, you can bypass probate court with a revocable living trust. It enables you to skip the probate process entirely. You choose who manages your assets. You choose the caregivers and guardians of your dependents, if that's an issue for you. A revocable living trust. By creating a properly funded trust, which is a legal contract valid in every state, you never need to redo your documents if you ever move. You can access your trust and make changes without ever returning to a law office again. Your successor trustee, who you name, is already empowered to manage your trust after you pass without probate. Your successor trustee may be a trust company if you don't have anyone that you can trust to manage your trust. Now, how do you create documents? Well, you certainly don't want to do it yourself. I don't recommend that. You want to hire a local attorney who specializes in estate planning. You can DIY it with website tools. Again, you don't want to find out after you're gone that you did it all wrong. Your company may have a legal benefit through your employer that you can access to create estate planning documents. Or today we have cloud-based estate planning where we go online and with the help of an attorney, we draft documents that you can access and update online. So things to consider when naming your trustee: do you choose a person or a trust company? If you choose a person, can you change it later? Well, yes, you can, and you can enable that person to appoint um, an additional co-trustee to help them manage assets. So you want to think about the family dynamics, the age and competence of the people that you're going to put in charge, as opposed to selecting a corporate trustee, which may be advantageous um, in your situation. So here's your checklist for estate planning. Review your existing documents. Who's going to oversee the estate? Who can I trust to manage the assets? Who will be my healthcare agent? And am I truly protecting my beneficiaries? You may be sitting on an estate planning ticking time bomb, and you might not know it. What's your next step? Well, reach out to our office. We can help you with these issues. If you're in New Jersey, we have attorneys we work with locally that are very affordable and knowledgeable. We have attorneys in New York, in Florida, but also we have access to online drafting tools with the help of a service that provides the attorneys that provide that execution. So we can help you with all these things. My name is Jim Noble. I'm a certified financial planner and wealth manager. And this has been the fifth step of your retirement journey. Thanks for participating, and I look forward to hearing from you.